Okay. Well, let's see. I'm going to build on some of the comments that have been made before, particularly those dealing with procedural justice. The question that I'm going to look at is how can ADR foster the rule of law? And I say this is beyond the fundamental intention. The fundamental intention, of course, I laid out at the very beginning, and that is, how can you have a rule-based process on the one hand, supporting or being supported by a process that doesn't necessarily rely on rules. The question is, doesn't that non-rule-based process actually undermine a rule-based process? And that's really the rule of law critique that I mentioned at the outset. Well, I'm going to submit during the course of my comments to you that not only is this fundamental tension really more of a paradox than a tension, but I'm going to submit to you that rule of law process, excuse me, that ADR processes, and I'm going to talk particularly about collaborative governance processes, can actually do more to support the rule of law than the rule of law processes themselves. Okay, so that's where I'm going with this, and my approach is what I call an integrated approach that is sort of upscale for fragmented. But what I'm going to do is I'm going to bring together different sets of theories to explain what I've just suggested to you. First of all, conflict theory, social capital theory. Some of you may be familiar with that. It comes from political science, but it's also been used in other contexts, business especially. Procedural justice theory, which Rebecca talked about this morning, and a touch of democracy theory. Now, I'm going to approach this really, to begin with, from the standpoint of conflict theory. And we, on the conflict theory side of things, would look at this whole situation and say, this is really about group conflict, and that we'd say that intra-group conflict is inherent within any social group, whether it's a group of 3 or whether it's a group of 3 million. That it's just that simple, and it gets back to this Hobbesian idea that in a state of nature that we're all out there, we're striving to survive, we're striving to achieve, and in our state of nature, we are somewhat chaotic or anarchic, I think is the word that we use. So that's before law, and so one of the reasons historically that we've thought about the need for law is to constrain people in their state of nature. And so that, from a conflict perspective, is really why we have the rule of law to begin with. It really exists to bring order to what would otherwise be chaos and anarchy, and lots of conflict. Now, it doesn't have the conflict go away, but it does bring order to it. And I want to suggest to you that government does this. It can really do this in one of, I don't want to say 2 ways, but the ways in which that it can do it really fall along the spectrum that when I teach this stuff, I call it the dispute resolution continuum. On one side of the continuum, you've got adjudicatory approaches. On the other side, you've got consensus-based approaches. Adjudicatory approaches are things like trial, and indeed arbitration, where there's a third party actually deciding the dispute. In other words, the resolution to the problem, to the conflict that all of this is about, comes from top down. That the judge decides, arbitrator decides, and so on. On the other side, you've got consensus-based processes, and in those processes, like negotiation and mediation, as Rebecca was talking about, in those processes, the parties themselves decide. They can they can bring a third party to help them decide one way or another, such as the facilitation of communications or early neutral evaluation. But that's what the third party is doing, is helping the parties decide. So that's really the range of possibilities here. And though that range applies to government as well. Now, the traditional approach to this kind of conflict regulation is what we can think about as the rule of law. And what it looks like really is adjudication. The government decides. With respect to public issues, the government, speaking through the legislative branch, maybe the executive branch, decides, what the law is going to be. Now, it can be just on public issues, it can be regulated private behavior, but it's the government deciding. We also have the law application process. Again, the government's deciding. The judge is deciding how that law that was set up by the executive and legislative branches is going to be applied in a particular case. So, again, it's adjudication, and the role of the citizens here with regard to lawmaking is to elect the people who are going to make the laws, to inform them in their process, we might say lobby, whatever, and to persuade them to draft laws or regulations, implementing laws in a particular way. But that's what they do. They don't really engage in that process per se. Now, with regard to law application, what the citizens do is they bring claims that will vindicate their rights and then perhaps clarify the rights of others. Now, from a conflict perspective, this is a little problematic, and I don't want to overstate this because a lot of it works just fine. But let me just point out the problems with it. First of all, it is resource intensive. The old saying, it takes an act of Congress to do this. I mean, when you're talking about an act of Congress, it really does take an act of Congress to enact an act of Congress. And this takes a lot of time. It takes a lot of money, and it is challenging. And then you got to get the president to sign it. So it really is very resource intensive. More pointedly, though, is it sets up a win-lose paradigm. Okay, whenever you've got adjudication, whenever you've got somebody deciding what's going to happen to others, somebody's going to win and somebody's going to lose. And what this does for some, not every one of the losers, is set up a regime of resentment. They lost. I think that Rebecca mentioned nobody really likes a bad outcome for them. And so when they get it, they are, they're disappointed and somewhat resentful of what happened. This can foster distrust in the institution that is doing it, whether it's the legislative branch or the executive branch or the judicial branch, and that in turn can create a problem of non-compliance for the very reasons that Rebecca was talking about. So the problem with this win-lose paradigm for rule of law purposes is this culture of distrust that, is this problem of non-compliance, especially problematic in developing countries where there's already this problem of distrust to begin with that Bill was talking about. Nobody trusts anybody. So this is problematic. The procedural justice literature, I won't go over that in detail, but just to say that, to summarize what Rebecca was saying, it says that compliance is really a function of the process as much as if not more than the substance of the law, and that compliance in turn hinges on the degree to which that process was predicated or fulfilled or exonerated the values of voice, neutrality, and dignity. Now, the problem with traditional rule of law processes is that they really don't. Okay? They provide very little role for individuals. I mean, how many of us really can go to Congress and get them to enact a law and get it signed by the president? That's not something that individuals can be influential in mobilizing support, etc. But we can't do that. Same thing on the regulatory side with administrative agencies. In courts, we can do that, but half the time, in other words, the time that you're the defendant, you don't want to be there to begin with. So, there's, and even then, I should say, with regard to this particular element, the real heavy lifting is done by the lawyers. You're the bystander in a sense. So, with regard to voice, not a lot really in the traditional rule of law processes. With regard to neutrality, they're often perceived as favoring special interests. When you think about legislation, I mean, how many of us really think that, when Congress gets together, is trying to achieve the common good? Okay? You're laughing over here, and that's my point. I mean, it just doesn't happen. Now, we can debate that, what the definition of the common good, whether even a common good even exists, right? But the concern and the perception often here anyway is that it's that it's really about special interests and which special interests are going to win. And I suspect that it's not too different in the world that Bill and Jim have worked in internationally, that there's concerns about the government really speaking for a very specific few people, i.e., the despot, in fact. And so, this is a problem. This is where the concerns about corruption come in. And then finally, from a conflict perspective, these processes really are about rights. They're not about the problem itself. In other words, what Congress does, or what a legislature, state legislature does, or a legislature, what any legislative body does, when it passes law, it basically creates a right if you've been harmed. Okay? In other words, if you've been harmed, you get to go claim something, right? Whether it's money or whatever. But it doesn't really address the underlying problem. It doesn't really do that. That's not what its capacity is to do. So a real limitation on the on these rule of law processes is, with regard to conflict, with regard to problems, is that they're not designed to resolve the problem. They don't even have the capacity to resolve the problem. They'll give you an answer, what to do, but they don't solve the problem. Now, this is in my view, in contrast to ADR processes. And let me just speak to the issue of arbitration. Arbitration is an adjudicatory process where a third party is issuing the decision. No problem with that. The way that it works, some might say should work, here in the United States is that it is a voluntary process. We can certainly have a rich debate about whether it's voluntary, but let's just assume it is. And it is absolutely fine, as far as I'm concerned, if it's a voluntary process. But what I want to focus on more is this other side of the spectrum, the consensual processes where people are actually. I do think that in adjudicatory processes, not just arbitration, but also courts, we need to think about the degrees to which they fulfill procedural justice values for the very reasons that Rebecca was talking about, but my emphasis is elsewhere. Now, what do these ADR processes do? Well, first of all, they provide access to justice. You can actually get someone to hear you, right? And that's different than the kind of waiting in line of long delays that Jim was talking about. You can actually, get in the door, regardless of what the process is. Not insignificant. So it provides basic access to justice. Now, these consensual processes that I'm emphasizing also really square nicely with the kinds of procedural justice values that Rebecca was talking about. They call for voluntary and active participation by the disputant, not the lawyer. By the disputant. That's voice. They call for the disputants to agree to a resolution. Right? That's dignity. And that's self-determination. That's autonomy. That's empowerment. And this can be on the basis of a broad array of considerations, which may have nothing to do with the law. And that's fine. They also provide for facilitation by third parties who are obligated to be impartial. There's your neutrality. How is that impartiality assured? Well, that's a problem. But at least they don't have a stake in the outcome. In other words, they don't get paid based on, whether or not, or at least they should, if done right, get paid on the basis of what the outcome is. And they are subject, at least here, to the reputational market. In other words, if Wayne is a biased arbitrator or mediator, nobody's going to hire Wayne to arbitrate or mediate cases. So all these values are fulfilled. What's more, they actually solve the problem. They actually get at the underlying interests, needs, and concerns of the parties. Now, this is true, I think, in both lawmaking and law application. In other words, I think that these consensual processes, the values, of these consensual processes and ADR processes can actually work in court-related ADR as well as the process of making law. But it's the process of making law that we haven't really touched on that I really do want to speak to now. And this is this idea of collaborative governance. Lisa Bega, who's going to be speaking next, has done a lot of important work in this area. And the basic idea is to use the skills, competencies that we have developed over an extensive period of time in ADR, and to apply them to the process by which we will govern ourselves. And so the idea here is to engage the public in general and stakeholders in particular in the resolution of public disputes. And so what they do in a sense is, to the extent that our democracy is a representative democracy, what they do in a sense is they bring in a little bit more direct democracy into the process by actually bringing people back into the process, right? The first generation of these processes was called Regnegs, pioneered by the Emeritus faculty here, Phil Harder, and the idea there was to bring stakeholders into the public process, into the process by which administrative regulations, binding administrative regulations, would be developed. Now, this was fundamentally different than the standard way of doing things. The standard way of doing things for what's called informal rulemaking is that the government holds hearings, takes testimony on a given issue. It could be climate control, whatever the issue is, and thanks everybody very much, goes back and decides what the rules should be, and that's it. It's adjudication. What Phil proposed was that the government not be the lone decision maker, but rather that it seek out and get the right stakeholders at the table so that everybody could decide what the policy ought to be. And critically, as a part of this process, the government would have to agree to draft a regulation that would reflect the preference of the group, in other words, what the group came to believe. Now, there's been controversy over Regnegs, without question, but to the extent that, some matters are expensive, and question whether you got the right people in the room, and can it be captured, all this stuff is there. But you can see the difference between it and the traditional regulatory process. You really do bring the people, the stakeholders in, and one of the things that we have found is that compliance costs predictably, social compliance costs predictably go down. In other words, people, stakeholders have participated in the rule, and they're willing to abide by to a rule that they participated in the development of. This gets back to social justice. Now, we're in right now, I think, as the second generation. Phil's big article on this was back in 1982, almost 30 years ago. And now we see more town hall meetings. We see study circles where people in the community get together to talk about an issue, say race relations in the community, and to come up with recommendations for both the public and the private sector. Wonderful things. We see citizen juries that look at a particular issue, say waste disposal, and decide, what might be a good way of handling that. And again, it's a recommendation really to the government, although it certainly happened where governmental assistance was not really needed. There's also deliberative polling. This is a design of Jim Fishkin now at Stanford, where he takes a random sample of people and educates them on a particular issue, say, budget, and after a couple of days of education, polls them as to what their choices are after they've been informed. In other words, this is different than normal polling because they've actually had a chance to work with something about the issue, to discuss the issue among themselves before they actually vote. That's the added benefit. So this is the second generation of collaborative governance, and it's, I think, very exciting. I was just at a conference this past weekend in Colorado on this, and it's taking root. It's taking root. Now, there are, I think, a lot of benefits to this that really were down to the rule of law. One, you achieve better outcomes. Two heads are better than one when it comes to solving the problem. Bringing all the stakeholders together to say, how can we agree something should be handled is a good thing. You get better compliance, and that is indeed one of the benefits here is that you get greater compliance at less social cost. Another is, that relates to that, and that leads to that, is getting more buy-in from participants. They participated in this. The last one is the cultivation of social capital. The cultivation of social capital. Has anybody here ever heard of social capital? One, yeah. Thank you, Stephanie. I'll let you correct me when I'm wrong. What social capital is basically, it is the wealth of a group. The wealth, again, the group can be a small group, it can be a nation. But it is the wealth of a group that arises from the interactions of its members. Okay, by the networks they create, by the culture they create. Okay, this is what we call social capital, and good social capital, positive social capital, is something that emphasizes trust within and among people and between people and institutions. It emphasizes reciprocity between people. It emphasizes a spirit of community rather than naked self-interest. And in studying this in the context of democracies, Bob Putnam at Harvard wrote a fascinating book in which he looked at the transition in Italy, which included the breakup of one central nation into like 17 different democracies. Fascinating. But he studied all of it to see which ones were effective, which ones weren't effective. And what he found was that the effective ones were the ones that had high social capital, high positive social capital, where there was a civil society that encouraged cooperation, there was this culture of reciprocation of positive behaviors, trust, and this sense of community. The ones that didn't work, the democracies that were ineffective, would seem to find really in terms of being responsive to citizens and actually being able to solve and to be trusted to resolve citizen needs. The ones that were ineffective were ones where there were civic traditions of distrust in each other and the people, where there were civic traditions of distrust in government, where people were basically self-serving, no sense of community, where there was what I call unhealthy competition, where basically everybody was kind of stabbing each other in the back. And then finally, this sense of isolation and detachment. We're all, it's not like we're all in this together like you have when you've got high social capital, because I'm in it for myself. Robert Ringer, you're looking out for number one, right? So, I would submit, and there certainly should and could be research, empirical research on this, that this very idea can also be applied to the rule of law. In other words, that I think it's reasonable to infer that social capital, that positive social capital, has similar effects for the rule of law. An empirical question, I grant you, I think it's a reasonable inference. I'd love to test it. So let me just close by saying that I think that that when we think about ADR and the rule of law, that there are at least 3 benefits that we get from it that add more value than the traditional rule of law processes themselves provide, and that they can provide. The first one is greater compliance with the rule of law, an abundance of research. As long as it fulfills these kinds of procedural justice values that Rebecca was describing. So that's one, and that's sort of ground zero for instituting rule of law regimes in nations that don't have them. Secondly, I think that ADR, by these consensus processes, for the very reasons that I described, actually foster this social capital in a way that the traditional processes do not, and that this social capital is just as necessary for the support of the rule of law as it is for the support of democratic regimes. It resolves conflict, in other words, in a way that contributes to an environment, that supports the rule of law. I think Jim mentioned the importance of institutions. Clearly, institutions are important, but I think the research is pretty clear that institutions alone are not enough. And certainly that's what the social capital research would tell us, that institutions alone are not enough, that those institutions need to operate in an environment that will support rule of law objectives, that will support democratic objectives, and that are animated by the kinds of procedural justice factors that we've seen. So finally, in my last minute, it also provides a vehicle for access to justice. It provides a vehicle for access to justice that the traditional processes may not be able to provide, either because of corruption or because of space, location, geography, and not just access to justice, but also for a direct role in the creation of justice. And really, I think that's what it's all about. So, that's my 15 minutes of fame. Thank you very much. A couple questions, okay? Yeah, go.
I always found when I agree with someone, I always understand them to be very intelligent. And this sounds immodest, I apologize, but I just wrote an article in the paper that I'm all that talks about building social capital using collaborative processes.
Wonderful.
Dispute in Peru on at a gold mine, where we did empirical look at how people saw what they did and so forth. So I commend it for.
And you found a correlation between positive social capital and support for the rule of law?
Yeah, and it's a long story. I'll reserve it. I'm trying to say.
Read the article.
Yeah, read the article. Yeah, Jim.
Will you put the next to last slide up?
Yeah.
I'm struck by the very last set of bullet points with democracy less effective. I think that describes what's happening in the Congress right now. And I'm wondering whether you have a strategy for using, ADR to either evade the gridlock that I see there and I see increasing in our future as a way to have greater control over our destiny, because I don't think it's going to happen for Congress.
Yeah, I've got kids with braces and they play ice hockey, so I got to charge for that one. Just joking. I don't have a magic bullet, but I can say that at minimum what needs to happen is the cultivation of political will. In other words, I'm not the first one or the last one who will say that it's all about partisanship, basically about who's in power rather than about the substantive issues. And we need, as a society, simply to rise above that. And that's going to take political will. And that's one of the challenges, as the dispute resolution people here in the room know, is is whenever you're convening a multi-party process, one of the things that you've got to do is you've got to engage the commitment of the participants. And in the political context, we'll call that political will. So that would be the challenge. Can these processes help? Absolutely. In fact, I was a reporter with the Uniform Mediation Act. The chair of that committee, Judge Mike Getty, was a special legislative assistant to the Speaker of the House of the state of Illinois, and he actually used legislative mediation. He did legislative mediation to get through a couple of difficult spots on legislation. So can these be used? Yep. But they take commitment and statesmanship. Yeah.
To caricature one of your points a little bit, it sounded like part of what you were saying was that the rule of law doesn't provide rule of law values. Did I misunderstand you? And would you like to correct my misimpression?
It doesn't provide necessarily procedural justice values. And I think there's a difference between rule of law values and procedural justice values. In other words, rule of law values, I think, speak to things like the predetermination of rules. In other words, having rules known and published in advance of their application so that people know what to follow. Rule of law values go to equal treatment of both individuals and the government. Rule of law values go to the same law being applied to all people, right? Those similarly situated. Those are rule of law values. I absolutely think that traditional rule of law processes provide that. Although we can debate it, does O.J. Simpson get better treatment by the law than I do? We can certainly debate that, but I think those values basically mirror. But I'm not as convinced that they provide procedural justice values. So good caricature. Yeah. Last one.
What do you think the media plays in building or being detrimental to the building of social capital in society? I mean, I agree with you that building social capital has positive benefits for, any number of different things, including dispute resolution, including what your presentation was about. But it seems to me that so much what we see in the media is not helping build social capital amongst people in our society. Do you see that as well? And do you see the legal community having a role in working through that at all?
Yeah, I actually think that the media plays a huge role in the cultivation of social capital. I think it plays a huge role in the consolidation of the rule of law. For one, it serves an educational function. Every time you see the judicial or the legislative system actually working, right, that reaffirms your even nascent belief that it can work. And I think particularly in developing nations, it's important for those stories to be told. I also think that in addition to this educational function, it can also serve a watchdog function to identify areas where it's not working. So where the rule of law system is not, where there's corruption, for example. So I think those are important functions. It can also serve, I think, a more deleterious function. I think it can undermine the rule of law. And one of the veins of my research is actually on that issue of what is the impact of the media's coverage of conflict on the conflict itself. Interestingly enough, this is something that has never been studied by empirical researchers. I would have thought that they'd have been all over it. They're not. So I'm working with a guy at Wisconsin right now, the head of the mass communications department here, to actually to design an empirical model to test this. And I actually, because I absolutely agree with you that it's vital, to understand how the media affects social capital and rule of law, so that it can do a better job of cultivating better social capital in a way that's consistent with its own values. So I'm going to stop there, introduce my colleague, Lisa Bingham. Some people need no introduction. So that's it. No. Some people need no introduction. But Lisa, I'm going to do that anyway for Lisa. She is truly a revered academic in our field.
Stop. That's good. I need my
She
slide
has
up.
and she has done vitally important work in systems design, understanding systems design, and analyzing systems, and indeed she's working on a book on that now. I asked her to think about the problems that we're looking at today in that context. She's also done important work in collaborative governance, so she'll be factoring that into her thinking as well. And with no further ado.
And unfortunately, what little thinking I got to share was done at about 1:45 in the morning. So thank you very much for that generous introduction that I tried to cut off. And the book I'm working on systems design is with Stephanie Smith and Jan Martinez, and Stephanie's here. I'm always thrilled to come to Missouri and see many friends. The last time I was here is with Dean Gelly's symposium on creeping legalism, and I am visiting this semester at UNLV and bringing greetings, repeated requests over the course of the week. Will be the great greetings from Jean Sternlight and Sylvia Lazos, who used to be on the faculty here, and remember everybody warmly and speak kindly and well of all of you. And sometimes I think they wish they were back here. But, so I am trying to bring together different threads of my own research and learn from the various threads of research I've heard here today, and presenting to you some ideas that are very early. Yes, I'm not Richard Wilson. Very early in their development, with the hope that during the rest of the day you will help me flesh them out. The basic argument from what I was able to read that was posted in people's presentations on the website, and I am not a rule of law scholar, is that rule of law initiatives encompass good governance. I'm going to focus on the good governance piece. And I'm going to argue that good governance is a product of institutional and dispute systems design, that good governance entails collaborative governance. You can even find it in some of the legislative history on statutes about public participation, that collaborative governance includes not just dispute resolution, and I think I would like us to be a little more precise in our language, because there are multiple communities of practice and academic disciplinary communities working in these fields, and they don't use alternative dispute resolution to refer to their work. And so collaborative governance as an umbrella term would encompass dialogue and deliberation of deliberative democracy as one community of practice, collaborative public management coming out of the public affairs field as another, and ADR as we traditionally understand it, which does overlap. There's no question that there are commonalities. So then the final piece of the argument, which I'm going to sit down, is that in theory, I think it's possible to design governance to produce the rule of law by bringing in collaborative governance and participatory initiatives across the policy continuum. So the stuff that I was able to pull out so far and look forward to deepening is from the definitions of rule of law, a number of terms that related and cross over to the literatures on collaborative governance. Things like accountability. I categorized them roughly, and this is just a working distinction. There appeared to be procedural criteria and substantive criteria for the rule of law. And the procedural criteria went to processes for holding government accountable, separation of powers, for example. Transparency is a form of ensuring accountability. Judicial review, of course, is accountability, an equal having the opportunity for voice in governance is also a way of keeping the government decision makers in touch with the folks that are being governed. The independence of the judiciary is a separate and again strikes me as largely procedural criterion. This notion of equal justice of the law, access to justice institutions. That distinction, I think, is helping me think through some of this. And then this notion of institutions being efficient, and dispute resolution is sometimes touted as efficient, bringing efficiency to the table, effective, fair in the sense of not corrupt, and all of these. This is subject to some debate. I'm trying to cast as procedural. And then our substantive criteria, which I'm not going to speak to very much, actually. The big one seems to me to be protection of human rights, the Amnesty International family of rule of law initiatives, and then protection of property from expropriation, which I see as descended from the World Bank family of initiatives and things that go on with these bilateral investment treaties and international development. So, turning from these various criteria for rule of law that I think pertain to governance, dispute systems design, which has also been called conflict management systems design, and is also related to the institutional design literature in political science, and to the literature of my colleague at Indiana University, Eleanor Ostrom, who won the Nobel Prize last year in economics, even though she's a political scientist and was the first woman to do so. Anyway, she has and she's 77 and still teaching. And this is my role model. She has developed something called the Institutional Analysis and Development Framework, along with collaborators at the Workshop on Political Theory and Policy Analysis. And all of these streams, all of these threads of literature are related. But the notion is that institutions are nested. Stephanie developed with a colleague a framework for analyzing institutions in the context of dispute system design that looks, and this is just major headings, it's more detailed, but looks at their goals, processes, and structures, the stakeholders, the resources, and success and accountability. And I saw many of these features in Ambassador Michael's presentation earlier this morning. I think that there's a convergence of thinking about the need to bring a design frame to these rule of law initiatives, a more systems level design frame. I think there's also a convergence of thinking about best practices in design involve inclusive participatory structures. This is something that Mariana has argued for. This is something that the research that Rebecca was reviewing would support. Stakeholder-driven processes, and that if we do this, there in theory is the potential to improve the capacity of these systems to prevent, manage, and resolve conflict, which in turn will foster the rule of law. That's an empirical question. We don't have enough evaluation of these systems. I wish I could be as confident that we can assert that we are going to produce social capital and that we are going to produce rule of law, but I think that's a measurement question, and we need to do a lot more work. So that brings me to the connection now to collaborative governance. If participatory and stakeholder-driven processes are desirable, then how and where do we bring them in to this project to develop the rule of law? And the notion of collaborative governance is relatively recent. Jody Freeman used the concept, used the phrase in, I think it was 1997, in a paper to describe actually a number of different ways that federal agencies interacted with citizens and stakeholders, and the term has come to refer to decentralized, negotiated, collaborative, participatory relationships, and it includes these kinds of relationships with citizens, with non-citizens, undocumented workers, and with stakeholders, including civil society, nonprofit organizations, the private sector, the tribal sovereign governments, the whole range of possible actors. The arguments are, it's obviously participatory, also that the participation itself produces transparency, which is a value in governance, and also therefore produces accountability. It may or may not be more efficient. I think the word is out on that. I'm confused by the 15 minutes, because I thought I had a total of 15 minutes, and I have myself at about 8 right now.
You're right.
Thanks. Just check. Okay. So these silos of work all fall within the category of collaborative governance, and the examples that Richard's already given of deliberative democracy include these study circles, deliberative polling, and so forth, and Peter is going to talk about these kinds of processes in more detail, so I won't here. The thing that I think gets short shrift a lot in our conversations actually comes out of my home institution's discipline, which is public administration and public affairs, and that's a whole body of work on collaborative public management. And a lot of, if you think about the rule of law effort internationally, it's a perfect example of these efforts of international institutions, international NGOs, governments to collaborate to implement rule of law initiatives. And this form of work involves negotiation and dispute resolution among stakeholder groups. It tends to overlap a little bit with public policy dispute resolution, but it is an independent siloed body of work that I think has gotten a little bit of short shrift. So previously I had argued in the symposium here that if you lay this stuff out across the policy continuum, it tends to cluster. So the policy continuum is this notion that, and it's an artificial straight line, that we have legislative processes that are, or quasi-legislative processes that make policy. We then move to executive policy branch work, implementing policy, and then downstream to quasi-judicial and judicial activity, public agencies in the executive branch doing the quasi-judicial bit, and the judicial branch. And not all governments split them into branches, right, but their functions, enforcing policy. And if you look at the kinds of collaborative processes, they tend to cluster. Deliberative democracy tends to get practiced upstream in making policy. Collaborative public management tends to show up at the boundaries, and it primarily around implementing policy, particularly wicked problems, policy around wicked problems, like global warming, right? It's not like command and control is going to work very well. That's why we have this literature on collaborative public management, and this is the point at which I want to make the argument that it's a false dichotomy to distinguish between the rule of law and these collaborative governance processes. That basically, we've always had collaboration. Command and control doesn't always work. We can't establish the rule of law exclusively through command and control. And so I think it's more productive to talk about the how question, the design question, than to have a lot of argument over this potentially false dichotomy. So we look at rule of law failures, and the rest of this project for me would be a mapping project. To map the rule of law initiatives and the rule of law failures across the policy continuum as a way of helping us tease them apart and start thinking about them systematically. So just by happenstance, I've been, had the great pleasure of being at the Boyd School of Law this fall, which means I get to go to all these wonderful symposia that don't happen in my school, where we, this week we have somebody talking about groundwater flows because it's a school of public and environmental affairs. And next week we have somebody talking about the flooding of the upper Midwest with global warming. It's just not quite as on point sometimes for me. And so here I was able to sit in on a wonderful talk by someone who's on a kind of Truth and Reconciliation Commission in Brazil, and learned for the first time that the legislation around amnesty after the military coup in the 70s, and my history is very bad, the military government in power at the time actually pushed through legislation to grant itself amnesty in advance. And then that amnesty attached to crimes committed after the amnesty law is passed. How cool is that? So I want to get me some of that. So this notion of, well, there's a legislative branch rule of law failure if ever I saw one, right? Executive branch, I was able to sit in on this wonderful program that's touring the country from the Federal Judicial Center. They're trying to teach federal judges about the rule of law using the Third Reich, and it's this great program developed by the Holocaust Museum, and it traces how Hitler passed laws to basically legitimize and give the appearance of legality to what was going on in the Holocaust, and how the judges bought into it, and how they rationalized what they were doing. So we had this, the first step was effectively eviscerating separation of powers and eliminating the legislative branch. So there's essentially a rule of law failure in the executive branch. And then it passes down to the judicial branch, where they create this case law to legitimize what's going on. So, I'm down to 1 minute. So anyway, what I want to do is to map across the branches examples of initiatives that relate to the rule of law. And so legislative branch, we're talking substantive laws on transparency, public participation, the legal framework to support mediation and dispute resolution. We need law to create the framework to support these other processes, to support dialogue and deliberation. And you could use dialogue and deliberation to help think through, identify the problems and solutions that went into legislation. Executive branch interventions, well, this notion of releasing, they're still arguing in Brazil about releasing all the documents about the disappearances and the crimes, the political crimes that were addressed by this anticipatory amnesty act. So various executive branch examples would include the Ministry of Justice in Brazil created an amnesty commission of its own to try and get at the whole truth issue that wasn't being gotten at by other structures. The Obama Open Government Initiative is another executive branch example of a participatory process, although unfortunately most of it seems to be online so far. But that would appear on the map under the executive branch. And then the judicial branch examples, we've had discussions about restoring indigenous and local dispute resolution structures. That there's a project on mediation in Rwanda that Carlos Bernard is involved in. The Crespo example of the multi-door courthouse and other decentralized institutions. But interestingly, commercial arbitration to protect people from corrupt judiciary and the expropriation of property, I think also falls into this category. So that's unfortunately as far as I've gotten, and I look forward to all of your help deepening the analysis. Thank you very much.
Any questions? Just a few minutes for questions for Lisa. Over here. Or not?
Is there consider a little more, like, why do you see the need to make sure it's done at level?
Can you repeat the question?
Yeah, the question was why the need to move to the systemic level? Because the various interventions interact. You can't simply have a dispute resolution intervention downstream in the judicial branch without some framework authorizing the judicial branch to use the process, or in the executive branch. You will run up against resistance. So, for example, one of my related pieces of research right now is looking at the problem of getting the United States federal executive branch to use dialogue and deliberation, to embed it and institutionalize deliberative democracy. And you run up against in-house counsel who are risk-averse, and there is nothing in the Administrative Procedure Act or the amendments to it, the Administrative Dispute Resolution Act or Negotiated Rulemaking Act, that use the words dialogue or deliberation. Title V doesn't contain the word collaboration or network. So you have these risk-averse, terrified of the Inspector General, managers who are saying, hey, I don't have the legal authority to do this. To give another example on the local government level, local governments in California are trying to hold public deliberative processes in which they provide simultaneous translation because not everyone speaks English, and in fact, that's in California we have many vibrant immigrant communities. And what happens is you get the disgruntled taxpayer saying, wait a minute, you can't pay, you or community cannot pay for simultaneous translation equipment. Where are you authorized to offer public meetings anywhere but in English, right? And the finesse is actually nonprofit organizations do it, like the Institute for Local Government. But these kinds of legal authority issues can only be addressed by the legislative branch upstream, and yet they affect what happens all the way down, down the continuum. So the argument for the systemic level is, if you want to embed and institutionalize this stuff, you have to have the legal framework for it to support, and the resources to support. Is that okay?
One more question, anyone?
Or not. Thanks very much, Lisa. Here is where we take the great leap into the unknown. We're fortunate to have the technology now to actually bring participants in from across the world, and hopefully it will work.
So hi, it's really fun to be on the other side of the world and part of this conference. All right, so our symposium poses, I think, a really complex and recurring question. Is ADR in tension with the rule of law? And everyone who's spoken, I think, has exploded this question for us in very productive ways, but let me still say that one quite common way to make sense of this question is as follows. ADR is private. Its various institutions evade public adjudication through informal, consensual, and situational techniques of social ordering. Rules of law are public. They emanate from the state, are applied by official decision makers generally to all. So, for example, scholars like Gene Sternlight recently summarized a list of arguments indicting ADR for undermining the rule of law precisely because of the various ways it transgresses the public-private divide. So if rule of law concerns prompt writers to link ADR to the problems of privatization, then I thought it was worth exploring how ADR proponents themselves understand the private sphere. So opponents of ADR have described the privatization of dispute resolution as part of a broader shift from state to market forms of regulation and control. But in the 1970s and 1980s, some of the most important architects of ADR developed dispute processing theories and techniques through work that did not originate in the private sphere of the market, but rather that of the family. So think here of Frank Sander, Bob Vanuken, Jay Fulford, among others. So the paper I have today is going to suggest that attention to how ADR transgresses the family market divide, not simply the public-private one, helps to illuminate its vision of private ordering. So now in ADR writing quite broadly, the family recurs as a model for thinking about other kinds of relationships, even in spheres that are commonly thought to be purely commercial or transactional in nature. Now today it's quite ordinary for ADR proponents to transfer dispute resolution models and techniques between family and market domains. But this conflation of paradigms is actually quite intriguing because, as family law scholar Janet Halley has shown, for much of the 19th and 20th centuries, American legal thought has virtually required the division of intellectual labor between the law of the family on the one hand and the law of the market on the other. I'm actually going to begin this talk with a bit of history to try and show how interesting ADR is on this score. So now by the turn of the 20th century, classical legal theorists had imagined the market and the family to operate basically in entirely different ways. In brief, the market was imagined as an institution organized around, quote, individual will, private pleasures, selfish intentions, and hard bargains, and I'm quoting Halley here, whereas the family was imagined as an institution organized around, quote, affective, sentimental, altruistic, and morally saturated relationships, end quote. As such, the family couldn't be governed by the laws of contract that ordered the marketplace, and so emerged the division of private law into two competing domains, the first dedicated to human dependency, the second to individual will. And these two domains, the family and the market, became important early sites for experimental dispute processing reform. So now also by the turn of the 20th century, court reformers were fashioning alternatives to formal adversarial adjudication. And it's common in ADR writing to sort of harken back to a moment, to the time of Rothko-Pound and early 20th century dispute resolution reform. But significantly, in the family context, reformers envisioned informal procedure as social and public, and in market context as individual and private. So let me take family courts first. When family courts cropped up throughout the country, they shared the following characteristics. First, the methods of producing evidence and conducting proceedings were emphatically anti-formal. Second, these courts usually promoted conciliation. Court staff would aim to repair and construct family relationships without invoking formal law. Third, these courts were explicitly extra-legal. They combined informal and anti-adversarial proceedings with social scientific expertise aimed at treatment and reform. And even more, reformers understood these courts with their ad hoc, situational, informal techniques as public rather than private. Through informal conciliatory procedures, the state could demand that the family behave in solidaristic, altruistic ways. And the state was properly engaged because reformers explained the family, not the individual, as the primary unit through which society and the nation-state is reproduced. So in family domains, progressive-era reformers rejected formal adversarial adjudication, not to promote individual autonomy, let alone to privatize public conflict, but rather to promote social welfare, collective responsibility, and the national public good. So during the same period, reformers also called for alternatives to litigation in commercial disputes. But if conciliatory procedures administered in family courts were understood as both social and public, adjusting mandatory family relationships of duty and dependence on behalf of a national social good, conciliation and arbitration in commerce were understood as individual and private, carving out spaces for putative equals to adjust their own economic relationships in the marketplace. And commercial lawyers widely called for democratic conciliatory procedures, and more significantly, described these procedures as a proper response, to quote one lawyer, to quote the vast and steady stream of social legislation that is so characteristic of our young and growing republic, end quote. Or to quote another, to be publicly hauled into court, and these are all from the early 1920s, hauled into court to settle a mere private dispute, unless all other methods fail, might rather be regarded as an invasion of the sacred right of privacy, end quote. So in clear distinction to their domestic relation counterparts, and there's a lot more detail in the paper that might be floating around that I submitted, but in clear distinction to their domestic relation counterparts, commercial reformers promoted consensus, cooperation, and extra-adjudicatory procedures to facilitate private autonomy, not the public or social good. So consistent with separate spheres ideologies, reformers understood family conflict as the proper concern of society and the nation state, preserving for individuals and private rulemaking matters such as commerce and trade. All right, so now with that very, very condensed history, let me now just jump to the modern ADR movement. And to begin, in the 1970s and early 1980s, I think writing on family ADR had a really transgressive edge. Scholars proposed borrowing ideas about dispute processing from the market, typically from business and labor relations, to restructure family disputes. Now, this new crop of reformers made clear that the dispute processing procedures they envisioned utilized private contract, not the social therapeutic interventions of early 20th century family courts. In scholarly and practical writing, ADR proponents taught family members to learn literally how to trade. When family ADR advocates thus reconceived the family as a site of contractual relations in terms that reflected a renewed commitment, here we are in the 70s and 80s, to the privacy and autonomy of the individual, as well as to a decreased role for the state in family as well as market affairs. So the state, now to quote Jay Folberg, should use its increasingly precious resources to intervene in economic relationships between adults only when all efforts for private ordering or settlement fail, end quote. So from this perspective, families constitute private economic relations. Families, like market actors, should govern themselves through contract rather than remain subject to the intervention of the state. So these early ADR proponents thus self-consciously described family ADR as a form of ordering, to quote Bob Mnookin, premised on the notion that bargaining involves rational, self-interested individuals, end quote. Yet even as ADR proponents brought to the family free market ideas of private contract and individual self-interest, they didn't refuse, as either a conceptual or a political matter, traditional distinctions between the market and the family. To the contrary, their writings are full of the appreciation for the sort of specificity of the family as a site of conflict. Most writers describe the family as a place of intense emotion and unequal dependent relationships. Some suggested that family mediators should minimize the, quote, impersonal, acquisitive, manipulative, instrumentally rational values of the marketplace in favor of those distinctive values of the family, such as personal regard, respect for autonomy, sharing, and appreciating intrinsic goods, end quote. So in the early 1970s, and early 1980s rather, family ADR reflected a sort of uneasy mix of two modes of human interaction that were kept largely distinct by progressive era dispute processing reformers. On the one hand, ADR proponents borrowed the assumption from theorists of market-based exchange that individuals involved in family disputes are private, self-interested actors. On the other hand, they emphasized the importance that emotion and notions of duty and altruism play in family disputes and their resolution. So now, in the years that followed, ADR proponents actually used the dual model of the family envisioned in ADR to build more capacious theories of dispute resolution writ large. And to take just one example here, consider the scholarship of Bob Mnookin. Some might think, he argued, quote, that the stresses and emotional turmoil of separation and divorce undermine the essential premise of private ordering, individuals' capacity to make deliberate judgments. I disagree, end quote. Emotional relationships, as well as inequalities and externalities, he argued, can and should be managed within private ordering regimes. Mnookin, in fact, derived his model of private ordering based on, he argued, the twin ideals of individual liberty and efficient exchange by theorizing the affective, unequal, and duty-bound relations of the family, not simply the arm's-length rational bargaining of the marketplace. And he concluded his very sort of seminal and widely cited Bargaining in the Shadow of the Law, which of course is all about family mediation, with what I think is a rather prescient claim. Certainly, he wrote, the model of dispute settlement that he and Kornhauser envisioned has, quote, implications far broader than family law, end quote. Now, by the 1990s, for most, if not all, ADR proponents, the sort of affective, interdependent relationship that long defined family disputes, in fact, defined disputes in a wide array of social contexts. So now just think of books like Beyond, I'm losing my battery, hold on. Okay. So here, just think of books like Beyond Winning or Beyond Reason. These contemporary writers clearly do not commend the use of conciliatory, informal, and anti-adversarial procedures by public institutions in order to advance a pre-existing national social good, like their progressive era family law counterparts. But neither do they necessarily commend procedural informalism to evade a steady stream of social legislation, right, like early commercial reformers. Instead, they seek primarily to enable individual disputants to manage the emotional, altruistic, and simultaneously self-interested relationships that cut across all the spheres of their existence. So if, as Claire Huntington recently argued, quote, the curative to separate spheres ideology is to see both family and market as effective sites, well, then ADR has accomplished an important analytical feat. It does not presuppose a sharp distinction between the family and the market. Now, as our symposium topic suggests, scholarly discourse on ADR has pursued this long, enduring debate about law and its opposites, right? Rights versus interests, state versus market, public versus private, and I think in this capacious sense, the rule of law and ADR. And I think this debate is entirely understandable. It reflects the genesis of ADR critique. In the late 1970s and early 1980s, critics argued that ADR would replace the social values embodied by the public state with a relentless drive towards individual utility maximization embodied by the private market. In the intervening years, we've witnessed an explosion of efforts that, like ADR, aim to restructure our understandings of privatization, in part by importing the putative norms and values of the family to commercial domains. So I'll just briefly conclude with a few examples outside of ADR. But over the last 2 decades, market theorists, like ADR writers, have introduced new discourses of the social into their conceptualizations of market-based exchange. And here I mean terms like social capital, social network, social trust, which is actually intriguingly a very different understanding of the social than we got during the progressive period. But here I'll just say that, very strikingly, several writers who understand the market as social in this way theorize the family as a paradigmatic social form. Just incidentally, many scholars trace the term social capital to an article by sociologist James Coleman, who researched how family relations among families, had an independent influence on children's performance in school. So the genesis of the term sort of comes in part from theorizing the family. Okay, but to offer just one quick example here, in 1995, Francis Fukuyama published a book in which he explored how families produce various forms of sociability, as well as how, quote, strong private economic institutions that go beyond the family, end quote, can foster similar forms. In fact, Fukuyama, most famous for his claim that liberal capitalism is the end of history, envisions a market economy comprised not of atomistic, narrowly self-interested individuals, but rather of explicitly social forms of organization. These forms are like the well-functioning family, but, quote, allow unrelated people to collaborate, end quote, because they foster social ties, moral obligations, and social solidarity that are not limited to the family, but extend to associational and professional groups. Right, so now when read against descriptions of the ideology of separate family market spheres, these are striking ideas. They're also ideas embedded into the fabric of ADR. So in this particular moment of late neoliberalism, I have not explored ADR's turn away from the institutions of public law and towards the institutions of the market. Rather, I've tried to examine ADR's far more complex, oppositional, even paradoxical understanding of the private sphere. Today, the social dimension of our collective life, the social dimensions of our collective life are being transformed from state-enforced entitlements, rights, insurance schemes, not only into rational cost-benefit calculations, but also into requirements to cultivate responsible social relations by market actors themselves. Against this backdrop, ADR offers a vision of private social ordering that's not easily dismissed. ADR promises new ideologies of interpersonal interaction that are powerful in large part because they disrespect prior distinctions between self-interest and altruism, rationality and affect, the market and the family. So now everyone here can judge for themselves what results, positive or negative, ADR has actually produced in the world. But as legal scholars and policymakers today debate the possibilities of configuring the market as a distinctly social space, ADR adventure should provide us with fertile conceptual examples and cautionary tales.
And Scott, Amy, hear us? She can hear us. Okay. So Amy, can you hear us?
Were you able to hear me?
We were able to hear you. It was a fabulous presentation. I don't know if you were able to hear the generous round of applause, but it happened, just so you know. Can you hear me now? Amy?
I can hear you.
Okay, great. We just have a few minutes before pictures and lunch, but I want to ask if there's anyone in the group that has a question for Amy. Peter Moberger does.
And you can hear me? Wow.
Can you hear him?
Yes, okay. Just a quick question. First of all, a wonderful talk, very interesting, and probably going to feed my thought about this area substantially. But one thing I'm wondering about, deliberative democracy theorists like Habermas would say that the whole view of the state is essentially a kind of market mechanism is flawed from the beginning. And they might view the advent of something like ADR with roots in family law as a corrective that begins to recognize the value of the community. Do you have any thoughts on that?
I think that's right. I think it makes a lot of sense in that to think of ADR as a corrective to any sort of dichotomy that tries to split the state from the market, or the state from the family, or the family from the market, right? And so if we're going to have a more complex understanding of community that transgresses sort of prior distinctions, I think one of the neatest things about ADR is to recognize how it moves, or it gets its energy from moving in between sort of binaries that we take for granted.
Good. Any other questions? Well, with that, Amy, we'll go ahead and say thank you for taking the real trouble to stay up as late to work with us from halfway around the world, if not further. You can go to bed now and know that you've done a job well done. Thank you so much, Amy.